Hello, everyone. We're going to talk about Ontario's Not-for-Profit Corporations Act, which is the act which replaces Ontario's Corporations Act. It governs most provincially incorporated nonprofits in Ontario. It came into force on October 19th, 2021. We will cover three things today. What's new in the ONCA, what steps do nonprofits need to take to come into compliance with the ONCA, and how can CLEO help? I'm a staff lawyer at CLEO, Community Legal Education Ontario, not the other CLEO. We are a legal clinic, part of Ontario's legal aid system that provides free, plain language and clear design legal information in a wide variety of areas: criminal law, family law, employment law, discrimination law, etc. It could be helpful to either you or your clients. So I encourage you to check out stepstojustice.ca and our Nonprofit Law Ontario website, which I'll be referring to throughout this presentation for more information on anything we discussed today. Okay, so disclaimers, you know how lawyers are. Number one, all of this is just general legal information, not legal advice particular to your case. I would need to review governing documents and know about your organization's history to advise effectively. This is a high-level overview of the ONCA, so it's not meant to be comprehensive. You can go to the website for more comprehensive detail, and it doesn't address other areas of law that may affect the governance of an organization you're dealing with or your organization. For example, charity law, employment law, if the organization is operating in a regulated field such as healthcare, childcare, long-term care, etc., there may be other laws which impact the governance. So I'm just talking about ONCA today. Thirdly, this is about law, it's not about best practices. As I like to say, just because something is legal doesn't make it a good idea. I'm going to be highlighting options today that are available to organizations under the ONCA, but just because it's an option doesn't mean it's necessarily appropriate for the organization. And then finally, this is about law. It's not about funders' expectations or donors' expectations or the community's expectations, particularly when we come to the new flexibility under ONCA around financial review. I've had several conversations with different funders that have told me that despite the new flexibility, we're not changing our position on when an audit is required. So funders are welcome to do that, to set higher standards than the minimums set out in the ONCA. So this land acknowledgement is for where I'm coming from. Normally I'm in downtown Toronto. The territories of the Mississaugas of the Credit, the Haudenosaunee, the Anishinaabe peoples, including the Chippewa and the Wendat. I'm very pleased to be here, as I mentioned earlier this morning, for the first time since I was a small child. And this too is the traditional territories of the Anishinaabe and Haudenosaunee peoples, although some different nations as well. I want to be very transparent about the fact that as a lawyer, I acknowledge my privilege and role in perpetuating systems of colonization that remain harmful to Indigenous peoples. And what that means for me as a nonprofit lawyer is that the governance systems and norms and expectations that are set up about who gets to make decisions and how decisions are made often crowd out other forms of governance. And what I want to highlight is that in the ONCA, there's often more flexibility than we realize. It sets a lot of defaults, and we need to be careful, both as lawyers and as people involved in the governance of organizations, to not treat defaults as mandatory rules, to understand when there's flexibility. This is an important insight, I think, not just for reconciliation, but for acknowledging and working with the interests of diverse stakeholders in our community. Now, typically when I give this presentation in a longer format, I tell a bit of a detailed story about two sets of treaties, but I'll give you the short form today. Basically, the lesson I want you to take away, if you take nothing else from this presentation, is the following. Legal compliance and good governance are not just about what you put in your governing documents. It's not a once and done process. It's something iterative, it's something about the underlying relationships, and it's about what's integrated into the practice. Very often I see lawyers working with organizations where the lawyer creates perfectly good, legally compliant governing documents, and then naturally they go away. Few lawyers have the luxury to stick around. And then what happens sooner or later, there's turnover, or it's not understood, the governing documents aren't written in a plain way, and then they fall out of use. Well, a governing document that's out of use from a nonprofit corporate law point of view is almost not worth the paper it's printed on. It's almost worse because it sets an expectation so that when that expectation isn't met, it can become an additional form of non-compliance. So what I want to emphasize is that when we talk about the transition process, we're not just talking about updating our bylaws, updating our articles. That's an important step in the process for many organizations. But the next step, which is how are we going to actually integrate it into our practice, is the more crucial step. And we can think about that step from the beginning in two ways. Firstly, by treating the ONCA transition process as an educational process for the board, for the volunteers, for those involved. And secondly, by including in the decision making about what the rules are going to be, the people who are actually going to have to live with the rules. This both builds buy-in, it educates them about those rules, and it helps to ensure those rules have been sensitized to their experience and the practical realities of the organization. For those not familiar with the history of the dish with one spoon treaties, it's much more an ideal of iterative, ongoing relational, whereas Treaty 13, the so-called Toronto Purchase, particularly between the years of 1787 and 1805, is like a classical example of written down on a piece of paper, filed away, not looked at for decades until someone got concerned, pulled out only to realize it had nothing to do with the facts on the ground. And so I use Treaty 13 as an example of the unfortunate realities that a lot of nonprofits face in their governance. So Ontario's Not-for-Profit Corporations Act, as I mentioned, is the general statute that applies to most nonprofit corporations incorporated in Ontario. It does not apply to federal nonprofits, so under the Canada Not-for-Profit Corporations Act, does not apply to co-ops, does not apply to condos, does not apply to unincorporated groups unless they want to become incorporated. They can do so under the ONCA. When we talk about governing documents, which I've already done and will continue to do in this presentation, what are we talking about? We're talking about the letters patent, that document the government first sent the organization when it became incorporated, including information like the purposes of the organization, the official address, the founding directors, and so on. This, under ONCA, is now called the articles. So when I use the term articles, and when you see the term articles associated with ONCA, it's referring to the letters patent. Secondly, bylaws. An organization may call it their constitution, their governing rules. As I like to say, a rose by any other name would smell as sweet. The key question is, do these documents contain the rules which ONCA expects to be put in the bylaws? Is the approval process for what's going in these governing documents mirroring what the approval process is supposed to be for the bylaws? If those things are the case, it's highly unlikely that a court would find that it's not bylaws just because it's called something like a constitution. And then thirdly, policies. So that might be code of conduct, confidentiality policies, and so on. ONCA does not have a lot to say directly about policies. So the focus of my presentation and most of the ONCA transition is generally about the articles and the bylaws. It's important to note, because I do get asked this, yes, almost all nonprofits have members. It's incredibly rare. If an organization doesn't know who its members are, that's a very good place to start, because as we'll discuss, membership approval is a vital step in any changes that are made as part of this process. Even if the only members of the organization are the board, which is a perfectly acceptable situation under ONCA, still it needs to be clearly distinguished when they're acting as directors and when they're acting as members. Directors, also referred to as members of the board, and officers include things like president, secretary, and so on. The only officer that's required under ONCA is a chair, and I'll talk a bit more about that later. So why care about the ONCA? I've found that organizations get more out of the ONCA transition process when they treat it as an opportunity to renew their governance. You can just treat it as, government requires us to do it, I guess we're going to do it. But there are new flexibilities, there are new ways to think about different things in the governance of your organization that you can take advantage of. And it can be a meaningful discussion opportunity. If you haven't looked at your governing documents in a long time, it can be a meaningful educational opportunity for different stakeholders in your organization and community. Now, two reasons that nobody needs to lose sleep over the ONCA. As I like to say, there are many better reasons to lose sleep. One, there are no ONCA police. It's nobody's job in the government to knock down your door and ask you, have you complied with ONCA? Rather, it's set up like a business corporate statute in that the directors, the members, the officers, in some cases creditors, have rights to take the organization to court. And often it doesn't come to that because people who are involved in the organization, in most cases, want it to succeed. The second reason no one needs to lose sleep is that it's not a major overhaul. I'll emphasize some of the big changes, but by and large it will be recognizable to individuals who are familiar with Ontario's Corporations Act, the preceding statute. Okay, so with that, what's new in the ONCA? 3 big things. So firstly, there's this new concept called a public benefit corporation. By default, under ONCA, all nonprofits face the same set of rules, but some nonprofits face additional set of rules. So that provokes 2 questions, naturally. Who are these nonprofits and what are these additional rules? Well, these nonprofits that face additional rules are called public benefit corporations. The way an organization comes to be considered a public benefit corporation is either, if they're a charity, they're a public benefit corporation. So that's pretty straightforward. Or, if last year they received more than $10,000 in grants, gifts, or financial assistance, so this means not fees for service, not in exchange for something they're contractually obligated to provide, some kind of gift type thing from public sources. Now, what does public sources mean specifically? Either government, federal, provincial, municipal, or an agency of government, or an individual or organization who is not directly connected with the nonprofit. And what does that mean specifically? They're not a member, they're not an employee, they're not an officer, they're not a director, right? So if somebody, let's say it's a government grant, right, that counts towards public benefit corporation. Let's say it's a gift from a foundation, that counts, unless the foundation's a member, that counts towards the public benefit corporation status. What doesn't count? Member dues, right, because it's coming from members. What doesn't count is selling courses, right, paying a fee to receive a course. That doesn't count because it's in exchange for something. So let's say, and I should say it's a year-to-year determination. It's what did we get last year, what did we get last year? So what are the additional rules? So the first rule that's different for public benefit corporations is who they can give their property to if they ever dissolve. So after they pay their creditors, if they have property left over, where does it go? For nonprofits generally, the answer is it could go anywhere. It could even go to the members. They can set out in the articles where they want that property to go. For public benefit corporations, they don't have that same flexibility. The property can only go to either government, federal, provincial, municipal government, or an agency of government, or if they're a charity, registered charities with similar purposes, or if they're a public benefit corporation that is not a charity, other public benefit corporations with similar purposes. Now, this rule, in contrast to the other 2 I'm about to mention, it lasts 3 years, right? So if a corporation is public benefit corporation in year 1, that status is going to persist for the purpose of dissolution for 3 years. The second rule is that public benefit corporations are only allowed to have a maximum of 1/3 of their directors be employees. Now, this is where I pause and remind you about the disclaimer. Just because something is legal doesn't mean it's a good idea. In theory, under ONCA, nonprofits could have all their directors be employees. Maybe in some cases that makes sense, but in other cases that will certainly be a red flag to many funders, and of course those individuals have to follow conflict of interest rules, so it can create logistical difficulties and so on. Every organization needs to decide for itself what's appropriate. What I'll add here is that beyond the ONCA, charities face even more restrictive rules about when a director can be an employee. There is a guide put out by the public guardian and trustee called Paying Directors and Connected Persons, which sets out the procedure that has to be followed if someone's considering paying a director for work they've done for the organization or their family member. And the circumstances are very restricted of when it's allowed. The last difference for public benefit corporations is they face a higher financial review standard than other nonprofits under ONCA. So with that, let's talk about financial review standards. So it used to be a fairly straightforward but inflexible rule. All nonprofits under the Ontario Corporations Act had to get an audit each and every year. Nonprofits who had annual revenue under $100,000 could pass pass a resolution at a members' meeting with 80% or more support at that meeting, or pass a unanimous written resolution outside of a meeting and waive the audit. Okay, that was only for organizations under 100,000. That is still possible. Right, so organizations with under 100,000 in revenue are still in that boat. They have to get an audit by default, but they can pass an extraordinary resolution and waive the audit, and that's fine. The changes come for organizations with annual revenue between 100,000 and 500,000 and higher. So for an organization that has annual revenue between 100 and 500,000, if it's a public benefit corporation, then they can pass an extraordinary resolution to waive the audit, but they have to still get a review engagement, right, which is a less extensive form of financial review. If they're not a public benefit corporation, they don't even have to get a review engagement. Up until 500,000, they can pass an extraordinary resolution, and that's it. No external financial review necessary. Of course, all organizations still have to create and put out financial statements and circulate those to the members. For organizations that are above 500,000 in annual revenue, if they're public benefit corporations, they have to get an audit, meaning nothing has changed for them between the Ontario Corporations Act and ONCA. They still have to get an audit. If they're not a public benefit corporation, then they have flexibility. By default, they have to get an audit, but they can pass an extraordinary resolution and waive the audit, but they have to at least get review engagement. The last thing I'll note in this section is the Ontario Business Registry, which many of you may be familiar with. It's not exclusive to nonprofits. It came online the same time that ONCA came online, October 19th, 2021. A good place to start for nonprofits embarking on the ONCA transition process is ordering a corporate profile from the Ontario Business Registry, because that will tell you what address and what directors the government has on file. And if the address is out of date, that will cause issues, because in order to access the Ontario Business Registry, you need to order what's called a company key. And how are you going to get the company key? Well, they're going to send it to the address they have on file, right? So the Ontario Business Registry allows you to do many things. One thing I'll note for charities is that it in no way replaces filings with the Canada Revenue Agency. And there are glitches, so watch out. Okay, moving on to the ONCA transition process. I'll focus on 6 steps. So firstly, figuring out whether ONCA applies to you. We talked about this briefly at the beginning. Doesn't apply to federal corporations, doesn't apply to co-ops, doesn't apply to businesses or unincorporated groups. One thing I'll add in this section is that if an organization is subject to multiple acts, let's say they're regulated as a child care provider or as a healthcare provider or something like that, a housing services provider, and they feel there's some kind of conflict between ONCA and this other act that they're subject to, they don't need to worry. ONCA is set up to yield to any other act. If ONCA comes into conflict with another regulation, ONCA yields to that other regulation. ONCA yields to common law, charity law principles, right? So ONCA is a very kind of affable fellow. There shouldn't be any conflict. Another question I get very often is, we're a charity, does ONCA apply to us? And the answer is, it might or it might not. ONCA doesn't care whether or not you're a charity for the purposes of determining whether it applies. ONCA looks at, where are you incorporated and under what act? If you're incorporated provincially and it's under Ontario Corporations Act or another special act, then it applies to you. If you're a special act corporation, there may be something in the special act which says ONCA doesn't apply, or sections of ONCA doesn't apply, but an organization would look at the special act to find that out. Okay, so let's say you figured out it applies. Great, when do we start working? How long does it take? So ONCA came into effect on October 19th, 2021, and there's a 3-year transition period ending on October 18th, 2024. During this 3-year transition period, the rules are as follows. ONCA applies, but the governing documents of a nonprofit that were valid before ONCA took effect continue to be valid, even if they conflict with ONCA. So there's kind of a bubble around the governing documents. But if there's some issue that the governing documents, the letters patent don't deal with, the bylaws don't deal with, then the organization is now looking at ONCA for the answers. At the end of the 3-year transition period, what's going to happen? Well, it's not that organizations will disappear. Rather, their governing documents will be automatically considered to transition over. So any non-compliant rules in those governing documents will automatically be considered to have changed to be compliant, with a few exceptions. So the exceptions are as follows. There are a few things that under Ontario Corporations Act it was typical to put in your bylaws, which now need to be put in the articles. However, if these things are not moved over to the articles by the end of the 3-year period, they won't cease to be valid. So these are the exceptions. So, number 1, the number of directors. ONCA now requires that the number of directors, the number of seats on the board, be put in the articles, although it was typical to put it in the bylaws. Number 2, if there are multiple membership classes or multiple types of members, groups of members, that needs to be put in the articles. However, if you have it in your bylaws, that it will continue to be valid. Similarly, if the voting rights of members are different from one vote, one member, that will now be required to go in the articles, but if it hasn't been put in the articles, that's fine. And then finally, the dissolution clause. I mentioned some restrictions on dissolution clauses earlier, but if an organization either is not a public benefit corporation or is a public benefit corporation and wants to add additional about what will happen to its property, it needs to do so in the articles rather than the bylaws. If it has a dissolution clause in its bylaws, that's fine. It will continue to be effective after the end of the 3 years. The practical takeaway from all this is that if an organization wants to change any of these rules, they're going to need to do so in the articles. But the current rules that I've just listed remain valid past the 3-year period. So how long does it take to transition? So typical quotes I've heard from lawyers who practice in this area range from 6 to 12 months. Some key factors to consider might cause it to take longer or shorter for an organization you're dealing with. The age of the governing documents, so when was the last time you looked at the governing documents? The capacity of the board, employees, or a lawyer you're dealing with to address these questions. How much consensus is there on the board or among the members or between the board and the members? Disagreement can be a very good thing, but it does take longer. And finally, the ease of holding membership meetings. As I'll soon explain, members need to approve these changes, so you need to get them together to do that. If that's difficult, then it can take longer. The next step is to get your books and records in order. Always a good idea. Don't need to wait for ONCA to do this. A few key things that I'll point out to you. ONCA, as did the previous act, requires all minutes to be kept. Minutes of board meetings, members' meetings, member committee meeting minutes, as well as board committee meeting minutes. And they can be kept virtually. They can even be kept on the cloud, and this is true of all records required under ONCA. They can be kept on the cloud, like Google Drive, for example. Another thing I'll call to your attention is the requirement to keep a members register, a list of the members, including their start date, their end date, their address for service, and their email address if they accepted receiving documents electronically. I note that the list of members is accessible to other members. Other members have a right to access this list, which can often be a source of tension or concern. And I can address questions if people have them about that. The other thing I'll point out is the director consent form. Directors do not become directors when they're elected, otherwise you could elect anybody without telling them, which might be funny, but wouldn't be legally effective. You need to get their consent in writing to serve as directors. It doesn't need to be a complicated form, and we have a sample on our website. Okay, so you've come to the point of reviewing your bylaws. What might need to change or what might you want to change? So here are some common things. Number 1, as I mentioned earlier, nonprofits are now required to have a chair. Previously, they were required to have a president and secretary. That's no longer required, although it's still possible. Now it's a chair. What I really want to emphasize is it has to be chair, not chairman, not chairperson, not co-chair, chair. Anything else will be rejected by the online system. Corporations can be members of nonprofits. The ONCA makes that explicit, but the governing documents have to explicitly say so that corporations are eligible. If there are multiple membership classes, then the bylaws have to specify how to join each class, how membership ends in each class, and how to withdraw or transfer between classes. ONCA sets as a mandatory rule that members who control 10% of the votes in an organization have the right to demand that a members' meeting be called by submitting a written request to the board. Nonprofits can set a lower threshold in their governing documents, but they cannot set a higher threshold. And then finally, by default under ONCA, proxy voting is not allowed for members. So if a nonprofit wants their members to have the right to vote by proxy, it has to be explicitly stated in the governing documents. What might you want to change in your articles? Well, your purposes. If this is the first time you're looking at your articles in many decades, you might find, whoa, we don't do that anymore, or wow, that language is outdated. This could be an opportune time to make those changes. The number of directors, it's now possible under ONCA to have a range of seats on your board as opposed to just a fixed number, so you may want to take advantage of that. If you have multiple membership classes, as I mentioned, this needs to be specified in the articles. And if the rights of any of those classes deviate from the one member, one vote rule, then those voting rights would have to be set out or alluded to in the articles. And then finally, if a nonprofit wants to restrict its power in any way, so for example, if it wants to say we're never going to sell this building or this land, or we're not allowed to borrow unless we have security or something like that, to be effective, that restriction has to be in the articles. So what's the actual approval process? So with the disclaimer that your governing documents may specify an approval process, in which case that may well be the process you need to follow, whatever your governing documents say, they cannot change the fact that membership approval is ultimately required. So here's the default process if your governing documents say nothing. So firstly, somebody proposes the changes to the board. It could be a committee, it could be a lawyer, it could be an individual, it could be an employee. ONCA doesn't specify. The board votes on it. When they vote on approving changes to bylaws, those changes are effective as of that date unless the board resolution says otherwise. And it's effective up until the next members' meeting, the next opportunity the members have to approve or reject. So the board can only temporarily change the bylaws. It's the members who cement any changes. Changes to articles are different. The board can vote to present it to the members, but changes to articles are not effective until the government approves them once it's been submitted to government. So the board, let's say they approve the changes to the bylaws and the articles, and then they present it to the members for final approval. So they need to either call a members' meeting, it could be an annual general meeting, or it could be a special meeting just for this purpose. They call a members' meeting, so it has to be a validly constituted meeting, or they get a unanimous written resolution. So this is a resolution signed by all the members entitled to vote. It can also pass that way. So what's required for a valid members' meeting? So there needs to be proper notice. By default, if the governing documents don't say anything else, that's 10 to 50 days of advance notice. Sufficient detail in that notice to form a reasoned opinion about what the members are being asked to vote on, and the notice needs to be sent individually to members. So any kind of just public pronouncement, let's say you post it on a Facebook group, for example, that wouldn't be sufficient. Although electronic notice, if it's individual, is possible unless the governing documents otherwise prohibit it. There needs to be quorum at the members' meeting. So by default under ONCA, quorum for a members' meeting is 50% plus one of the voting members. Now, don't panic if that sounds absolutely impossible to anyone here to attain. It's just a default. So it can be changed, it can be lowered, it can be made higher in the governing documents. Once the bylaws have been approved by the members, for an ordinary nonprofit, that's it, you're done, you're good as far as ONCA is concerned. You've got your changes. For a registered charity, there's an additional step of filing the changed bylaws with the Canada Revenue Agency. It's not that the CRA has the right to approve or reject these changes, it's just that the CRA likes to have these things on file. Now, the articles are a bit different. The articles need to be filed with the government, and this is the last kind of formal step in the ONCA transition process. There are three methods of filing. Number one, through the Ontario Business Registry. Number two, by mail. by downloading a form off of the Ontario Forms repository and mailing it in. And number 3, by working with a third-party provider that are listed on the Ontario Business Registry website. In order to access the Ontario Business Registry, you'll need 3 pieces of ID: the company key, the one key, and the Service Ontario account. Your organization or one you're dealing with may already have a one key or Service Ontario account, for example, if they're on Transfer Payment Ontario, but they wouldn't have a company key prior to the introduction of the Ontario Business Registry. So they may have gotten one between October 19th, 2021 and now. The way you get a company key is you go to the Ontario Business Registry website, you scroll down, you press a button that says Order Company Key, and you can enter your info and your address. That company key will then be sent to the address that the government has on file for your organization. That's why it's important to know whether they have the right address on file. If you want to download a form and mail it in, you're still going to need a company key. For the third party, however, you don't need a company key to work with the third party. They have direct access to the system and can make changes. The one thing I'd caution against is that if you're ordering a company key, avoid ordering it multiple times, because the second time you order it, it'll cancel the first company key and so on and so forth. So you'll get the first one in the mail and it won't work, and that'll be frustrating. Finally, how can CLEO help? We've got lots of free tools on our website, including a bylaw builder if you're building one from scratch or looking to work off a template. We have sample bylaws with options. We have a guide with a side-by-side comparison of the old Act and the new Act. We have pages on the pros and cons of different membership structures, more detailed information on all the topics we talked about, a directory of lawyers that work in the area of nonprofit law. If you or someone you know wants to be added to it, we don't claim that it's comprehensive. We neither vet nor recommend lawyers. We just check that some part of their practice includes nonprofits. And also, you can reach out to me, and I can provide general legal information, not legal advice. So thank you very much. I'm happy to take any questions now. Yes? Because it's being recorded, we've got a mic.
Can some of the more onerous portions of the Act be avoided by incorporating under the federal, or are they almost identical?
Do you have examples in mind of what you see as onerous?
The public, is it PCR?
Oh, the PBC?
PBC.
So there are some differences where it may make sense to incorporate federally rather than provincially. So for example, under the Canada Not-for-Profit Corporations Act, there's a concept called a soliciting corporation, which is the equivalent to the public benefit corporation, but the difference is it doesn't include charities. So an organization that's a charity but doesn't otherwise meet the $10,000 rule, it may find it simpler to be under the federal statute than the provincial statute. That's just one example. By and large, I wouldn't say the CNCA is less onerous. And in fact, when it comes to financial review standards, depending on where your income threshold falls, in many cases, ONCA may be less onerous.
Okay.
Any other questions?
Okay, well, thanks for listening, and you know where to find me.
Thank you so much for doing this.
Thank you.
We are staying in this room. You can feel free to walk around for a little bit.